akan memanggil Duta Besar Copyright China ke Malaysia berkaitan pencerbawan 16 pesawat tentera negara itu di ruang udara negara sebelah. Menteri Luar Datuk Seri Syamsuddin Tun Hussein berkata Malaysia juga akan mengeluarkan nota bantahan diplomatik kepada kerajaan.
Presenting trespass to land.
In ruling against the farm owner, the court examined a definition of trespass. It stated trespass means an entry on the property of another without having consent of the owner. To constitute a trespass, entry upon another's property need not be in person, but may be made by causing or permitting a thing to cross the boundary of the property below the surface of the earth. Every unauthorized entry upon the property of another is a trespass, and the intent or motive prompting the trespass is immaterial. Disputes about trespass to land have also centered around airspace, including ownership of the space above a property and an uninvited party's movement into that space. It does not, of course, include airplanes flying at airplane-level heights. While it is not 100% clear at what height a person's airspace ends, case law indicates that anything above 1,000 feet off the ground is certainly not within a property owner's airspace.
Assalamualaikum and good evening. On 3rd March 2015, the Department of Civil Aviation has lodged a police report following photographs of unauthorized flying vehicles or unmanned aerial vehicles UAV in the vicinity of Kuala Lumpur International Airport KLIA had been uploaded on social media sites recently. The drone, known as DJI Phantom 2, was believed was used by the operator has a flyaway issue and have encroached into airports which may disrupt and jeopardize flight operation, as UAV drones should be operated responsibly and flying it near any buildings or airport should have been prohibited. Any intention to fly drones or UAV in the Malaysian airspace requires approval from the DCA, said by the statement. It is also stressed that flying any UAV drones in the vicinity of airport is strictly prohibited and constitute as an offence under the Civil Aviation Act 1969. Malaysia kini reported that purported aerial drone photograph of airport approaching the KLIA had since gone viral, raising fear among netizens that it could lead to another aviation disaster. So this news is regarding the trespass to airspace, which is an invasion of the airspace above the land, but it is limited to the height at which the intrusion will interfere with the full use of the land. In this situation, an unmanned aerial vehicle UAV, properly known as drones, which are remotely piloted aircraft, have encroached into airports which may disrupt and jeopardize flight operations. Nowadays, drones have become increasingly prevalent throughout modern society and contribute a lot in entertainment, research, remote sensing, commercial use, rescue mission, aerial surveillance, and other various fields. At this current time, many states have not properly regulated the use of drones and enacted a specific law for that purpose. Lawmakers are aware that the drone industry is rapidly evolving and proper regulation on its operation is pertinent to safeguard possible legal concerns. Recently, Malaysia has followed through and enacted Civil Aviation Regulation 2016, which is part of the auspices of the Civil Aviation Act 1969. The supervising body is the Department of Civil Aviation of Malaysia, DCA. As such, drone owners are required to and expected to observe the rules and law applicable. The expected rise in the use of drones for a host of different applications may leave operator exposed to a whole new set of risks, including third-party damage or injury and liability. Risks include collision with aircraft, invasion of privacy, aerial surveillance, and unauthorized data collection, etc. The use of drones in residential and private property of an individual is a violation of their privacy, as it can take photos and videos of them, especially when flown in such a way that it can pierce into window, fence, backyard, or gardens. Domestic use drones limit our rights to personal privacy in a way that when a person operates his drone in the airspace, takes photographs and videos and further transmit the recorded data, to the remote pilot that ultimately result in the breach of privacy of an individual. The drones or UAV are the emerging threats not only for the military but also for the civil society. This could attain threatening dimension when carrying out unregulated, indiscriminate flying in the airspace while being used by the civil government. There is a need to regulate their use, identify and neutralize ground which threatens the privacy, security and safety of the civil society. Despite the multitude of innovative uses of drones, further evolution of drone technology face challenges in overcoming significant legal and ethical issues. So the next panel will discuss further in this matter.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Mohammad Nabil bin Razali, matric number 2114511. Okay, so in this presentation, I will explaining about the case that we had choose, which is relating to trespass to airspace, which is the case of Gelombang Jaya Sendirian Berhad against Jaya Jin Sendirian Berhad. Okay, this is a high court case. Now we move to the summary facts of the case. Okay, the plaintiff is an owner of a shop house bearing postal address number 93, while the defendant is owner of the shop house number 95. Okay, the plaintiff played as follow. Number one, they erected the advertisement on the rooftop of their premise with an approval from DBKL. And number two, the defendant had committed trespass on the advertisement by hanging banners and balloons, which had made them suffer a loss due to termination of contract with a third party. Okay, and then the defendant had intruded on the plaintiff advertisement by placing items such as flags, banners and balloons. And then the plaintiff claims against the defendant is for general damage as well as special damage for the loss they had suffered. Okay, and then the defendant however denies that it had trespassed and do nuisance to plaintiff's item, but the plaintiff who actually had trespassed his land and airspace which was directly above the defendant's property. And then we move to the principle involved in this case. Okay, in this case, the defendant contends that the banner, bunting and flags put up by the defendant were all time erected above the airspace of the defendant's property, which is shop lot number 95. And had never encroached into the plaintiff lot which is number 93 or its airspace at any time. And then the second one, we can see in the case of Kelson against Imperial Tobacco Company Limited, the defendant had erected an advertisement on his property, but it hung over 8 inches of the plaintiff property. The defendant was ordered to remove the advertisement. Okay, from these two ideas, we should know that it is important to determine who is the real occupier or the owner of the property before we can make an allegation. Okay, and then we move to the third point, which is in the case of Hunter and others against London Dockland Development Corp, and the case of Karupanan against Balakrishnan. From these two cases, it can be concluded that the rightful occupier of the land and airspace entitled to the exclusive use and enjoyment of so much of that column of airspace above the surface of the land and so much of the land below the surface as is reasonably necessary for the lawful use and enjoyment of the land. Okay, and then we move to the judgment and decision of this case. Before the judgment, the defendant is entitled to put up banners, bunting, flags and balloons in the airspace above its own property, so long as the defendant acts do not encroach into the plaintiff property or airspace above the plaintiff property. Okay, the court is hard put to find that there was trespass. And then the decision from this case is there was no trespass to airspace on the part of the defendant, and the plaintiff claims disclosed no reasonable cause of action as it is scandalous, frivolous or vexatious, and it is abuse of the process of the court. Okay, now let's move to the legal analysis from these cases. Number one, in order to prove trespass to land or airspace, it is a must to determine the real owner of the land or airspace. Failure to do so will result in the plaintiff to fail in his claim. And then number two, the occupier's right of the airspace only extended to such a height as was necessary for the ordinary use and enjoyment of his property. And then number three, Latin maxim, which is "Jujus et solum, ejus est isque et coelum et ad infernus," which means that the owner of land owns the space above it to heaven and the space below it down to hell, cannot be applied in these circumstances or in our nowadays law. Okay, that's all.
So, move on to the next case, which is the case of Terra Damansara Sdn Bhd against Nandex Development Sdn Bhd. This case is regarding trespass to land, trespass to airspace and subsoil. So, summary of the facts, the plaintiff and defendant are both locally registered limited companies owning neighboring lands out of which the dispute arises. The plaintiff is the registered proprietor of the vacant leasehold lands situated in Bandar Petaling Jaya and the district of Petaling Jaya, state of Selangor Darul Ehsan, namely lot number 330. Whereas the defendant is the registered proprietor of a leasehold land known as lot 331. The defendant's land is located beside the plaintiff's land that is in between Jalan 223/51A in the northwest and the Federal Highway in the southeast of Petaling Jaya. While the plaintiff is engaged in the business of investment holding, the defendant is a major automobile distributor. At the material time, there was on the defendant's land a double-story commercial building and it was occupied. Through a letter dated August 29th in 2006, the plaintiff's project manager, Mrs. Zaman Land Sdn Bhd, issued a letter to the defendant informing that the construction on the plaintiff's land will commence on September 1st, 2006. This claim was commenced by the plaintiff based on alleged trespass and encroachment by the buildings and structures on the defendant's land into the plaintiff's land, both above and below ground, thereby allegedly causing losses and damage to the latter. So here are the plaintiff's claims. The plaintiff obtained approval for the construction on its land, a 6-story building consisting of a mezzanine floor and a 2-story underground car park in accordance with the necessary approved plans, sometime on or about September 2006. Whilst the plaintiff's building contractors began construction of the said project, including earthworks on the plaintiff's land, they discovered that the defendant's building had encroached into the plaintiff's land, both underground and above underground. So, the finding of the encroachment, that the defendant's ground floor building wall had encroached into the plaintiff's land by 0.60 meter to 0.90 meter in width from the boundary of the plaintiff's and defendant's land, and 6.44 in length. Second, that the defendant's first floor building wall had encroached into the plaintiff's airspace by 0.63 meter to 0.79 meter from the boundary of the plaintiff's land and 10.65 meter in length. Third, that an apron and a drain of the defendant's building had encroached into the plaintiff's land by 1.29 meter to 2.395 meter from the boundary of the plaintiff's land and the defendant's land, and 54.82 meter in length. And fourth, that the 10 concrete blocks, which is pad footings with pillars attached and one straight footing, had encroached under the plaintiff's land by 0.465 meter to 0.926 meter from the boundary of the plaintiff's land and the defendant's land. In this case, the defendant also makes some claims, which the defendant claims that the plaintiff's and defendant's respective lands are adjoining lots and were previously owned by a common landowner. The previous common landowner had jointly developed the said lands from 1964 to 1969 and had obtained the approval of the local municipal council for the development of a semi-detached building constructed on both plaintiff's and defendant's respective lands. The common previous landowner had constructed structures which were intended for the support and benefit of any present or future semi-detached building built on the plaintiff's and defendant's respective lands. The alleged imputed structures discovered by the plaintiff were not built by the defendant, but were part of a building constructed on the plaintiff's land by the common or previous owner previous landowner. So the defendant did not construct or place any the alleged impugned structures on the plaintiff's land. The civil structural engineer and the architect who were appointed pursuant to the Shah Alam High Court dated in February 8, 2007 had concluded that the impugned structures were constructed or placed on the plaintiff's land between 1964 and 1969 according to the approved development plans, which were submitted to the authorities by the previous landowners of the plaintiff's land. A few issues that arises in this case are: first, whether the plaintiff had constructed the impugned structures on the plaintiff's land, whether the impugned structures were constructed in order to support a semi-detached building on the adjoining land. Third, whether the semi-detached building constructed with the approval of the local development authority, for example, Majlis Pembandaran Petani Jaya. And fourth, given the circumstances of the construction of the impugned structures, whether the defendant had caused the encroachment on the plaintiff's land. Fifth, whether the plaintiff had suffered any losses as a result of the defendant's actions. And sixth, if indeed the answer to number 5 is in the affirmative, whether the plaintiff took any steps to mitigate its losses. Judgment of this case was given by Gunalan Mulyandi J, who was the judge in this case. The judge said, on facts and scrutiny of the evidence, plaintiff's contention that the independent expert's evidence supported plaintiff's case and allegation against defendant is clearly erroneous and flawed. The evidence was unequivocal that any encroachment, if any, was minimal and within acceptable reasonable limits. Importantly, that it was not caused by defendant but the previous common owners of both lots intended by support a common boundary or party wall. The development plans then were duly approved by the relevant local authorities. The ground wall built along the boundary of lots 330 and 331 was attached to adjoining structures constructed on both lots. Hence, the question of unlawful entry or illegal construction which plaintiff rely on to sustain their cause of action for trespass and encroachment by defendant does not arise. Secondly, the overall evidence establishes that the boundary wall was a common wall with common shared footings which were within the allowable margins from the common boundary. As a result, the owners of both lots would have co-ownership of the said structures and the right in law to maintain the same along the said boundary as a mutual support for adjoining buildings. Thirdly, several of the structures alleged to have encroached onto lot 330, whether above or below ground, were not even shown to be connected to defendant's building on lot 331. Neither was any evidence adduced that defendants had allegedly entered into plaintiff's land and constructed these structures when they came to hold lot 331. Instead, what the evidence disclosed was that the structures were constructed by the previous common owners of both lots. Fourthly, there was no issue of trespass having been committed by previous joint owner of lots 330 and 331, who had constructed the original structure along the common boundary. Consequently, as there was no initial trespass or encroachment by the previous owners, defendant, as the subsequent purchases of lot 331, cannot be held liable for trespass in the absence of evidence of illegal entry or encroachment into plaintiff's land upon assuming ownership of the neighbouring lot. There was, in essence, absolutely no evidence of unjustifiable entry by defendant. So, the judge, Gunalan Mulyandi J, decided that plaintiff have failed to discharge the burden of proof borne by them under the Evidence Act to establish the central and material allegation on which their pleaded case against defendant is grounded, namely that defendant had illegally and wrongfully entered into their land without justifications and constructed the alleged impugned structures, causing them loss and damage as alleged. Plaintiff's claim, therefore, is dismissed with cause. After reading and analysing the case report, we unanimously agree with the judge's decision to dismiss the claim due to the lack of evidence. We agree with the opinion of the judge regarding the burden of proof. Plaintiff, as a person who wants to claim for trespass, must come up with proof proving that the defendant trespassed his land. A mere accusation saying that the defendant trespassed on his land is not sufficient to succeed in his claim. In Malaysia, those who want to claim trespass need to prove possession either in law or in facts, which in this case the plaintiff had successfully proved that he possessed the land. Secondly, the plaintiff needs to prove the intention, which is the voluntariness of the defendant in entering his land. There is no need for the plaintiff to prove the defendant's intention to trespass the land, as it is not important. In this case, there was evidence that the defendants voluntarily trespassed on the plaintiff's land. Thus, the second element was fulfilled. Thirdly, there is the need for the plaintiff to prove interference. The plaintiff must prove that the defendant committed immediate and direct interference with his land. However, the plaintiff in this recent case failed to prove interference since the defendant's interference with his building was so minimal and within reasonable limit. In fact, it was not solely caused by the defendants themselves, but it was the previous common owners of both lots who intended to support a common boundary or party wall. Thus, the plaintiff failed to prove the third element, as there was no direct and immediate interference committed by the defendants in this case. The last element is land. The plaintiff needs to prove the land on which the defendant trespassed was included in the definition of land in Section 5 of the National Land Code 1969 and 1965. With all the explanations of the elements, we believe that the decision of the judge in this case is just and fair. The defendant cannot be held liable for trespassing as he did not fulfill all the elements outlined.
Assalamualaikum and good evening, afternoon, and whenever you are watching this video. I am Mohammad Haqimi Adam. My metric number is 2112187, and I am going to make a review of a law journal article. Without further ado, let's do it. So this is an introduction for the review. The review was written and prepared by Deondre Nifloy. She was from Ireland, and this is probably an Irish law journal article titled The Tort of Trespass, Land, Air, Buildings, and Recent Case Law on Trespass and Receivers. So we have to put in mind that this law journal article was based on Irish cases, and there's a lot of Irish cases that have been cited in this case to support the argument and to be acted as an authority in argument. There are like too many points that have been discussed in this article by the writer. So the writer has been discussed about the definition of trespass to land, what constitutes trespass to land, what is the elements of trespass to land, the elements that can constitute and make you liable for trespassing to somebody's land. And also the writers also discussed and pointed out about the example of trespass to land, for example, trespass to land through the airspace, and trespass to land through the subsoil, and trespass to land to direct put your feet on the land. So that is all has been discussed, the basic stuff that we learn in our classes. For this review, I am going to point out the significant points that needed to be pointed out, that I think it is interesting and it is alluring and exciting to be discussed in this video, and also needed to be implemented in our country and need to know by the public that these people, this is something that you can do to defend yourself, something that you can do to get your rights, and something you can do to be legally right. So the first point that I would like to point it out in my review is whether is it permissible to commit trespass to carry out repairs to one's land. So according to this journal, it is not permissible to commit such an act if the owner does not give consent to it. This principle derived from the case of John Thurber Limited against National Westminster Bank, where the judge in his judgment mentioned that in circumstances where the plaintiff had refused to permit to the building of scaffolding on his land for this reason, the plaintiff secured an injunction restricting the defendants from trespassing on his land in order to make repairs to the defendant's property, which means if the owner does not give any consent, does not permit other people to enter the land, to fix anything on the land, it is not considered permissible and you shall be liable for trespass. And however, as the world goes on, the world spinning around, the law also is being developed. So the plaintiff may commit such an act. It is permissible to commit such act if it is necessary, pursuant to section 43 and 47 of Land and Conveyancing Law Reform Act of 2009, which permitting the plaintiff to commit such repairs on somebody else's land, even though the owner does not consent to it. So the second point that is really interesting and intriguing to be discussed in this review, that the court will not demolish a house that had been already built by the developer. So this rule has been derived from the case of Parkland Estate against Parkside Homes. In this case, it is concerned about a housing development where dwellings have been erected in violation of restriction covenant established in a land transfer several years prior to the defendant's purchase of the property. The covenant stated that a green tract of land inside the original estate wouldn't be developed for housing. Nonetheless, the site was sold to a developer who erected 14 dwellings or 14 houses on it some years later. The plaintiff filed a lawsuit to have the dwellings or the house erected in violation of the covenant to be demolished. However, the court agreed that the defendant had trespassed to the land. The defendant had violated the rights of the people. However, the house should not be demolished because in the eyes of the judges, it would be a massive waste if the house was demolished. Also, for demolition, it would take lots of cost. It would waste energy, a waste of time, and a waste of money. So in the eyes of the judge, the act of demolition the houses is not a right thing to do. And they believe by demolition the house, it would cause more trouble than solutions. So another point that I found really exciting and interesting to be discussed in this review is the court would not demolish a house that already been built. This derived from the case of Rotten Park Estate against Parkside Homes. This is an Irish case where the court decided to rule that the development violated the restricted covenant. However, the plaintiff did not have the right to a mandatory injunction ordering the demolition of the houses or the dwellings erected in violation of the restrictive covenant. In the judge's view, it will be a massive waste if the house was demolished. Also, for demolition, it would take lots of money and lots of costs in order to perform a demolition towards the house. And this is very great example of the rule of equity, where it is not really bring justice and peace by demolition, by destroying a house that already been built, because it's going to be a really such waste of time, money, and energy. So, for a better conclusion, the houses, regardless it is a straight violation of somebody else's land, it is not make any sense to demolish the house because it will create more trouble than solution. So the final point that I would like to discuss in this review, the point of trespass by receiver. So who is the receiver? A receiver is someone who a person or company appointed by a court to manage the financial affairs of a business or a person that has gone bankrupt. So the question arises whether the receiver has the right to the land, whether the receiver has possession in law to the land or possession in fact to the land. So in this case of Moorview Development Limited against First Active PLC, Clark Justice stated that a receiver has no rights, no power, no stake whatsoever in any lands that are credit represented as belonging to the firm to which the receiver has been appointed. This means that the receiver has no rights whatsoever towards the land, and if the receiver commit any act that could constitute a trespass to land, he shall be liable for trespass to land. So to sum up my discussion or my review regarding this article, I do find this article really interesting to read, and I do find that many points and matter that can be discussed under this article, and I've come up with best 3 points that I think is very relatable and very good to be discussed in our class and in our video for this particular assignment. So in my opinion, if we just take a step forward to look to the sky, look to the other's point of view, other's country point of view regarding an issue or legislation or a law, we can find there are many different opinions and different point of view towards an issue, not just about one issue, one solution type of thing. For my understanding, I do believe that one issue can be resolved with too many solutions if we look others' solution in others' country. So with that being said, I think that's all for me. Thank you. Assalamu alaikum.